And our guide in finding out about wills and separating facts from fiction is attorney Patricia A. Harold. She's an attorney practicing in the area of wills and estates for nearly 20 years and has offices in Garden City. In addition to helping people prepare wills, she also helps to probate those wills when it's necessary, and administering estates or involved in litigation of estates if the need should arise. So, Patricia, you've mentioned that a will is offered and the court would eventually approve it. Let's assume it all goes well and the will is probated, so the court is passing upon the authenticity of the will and that the will is going to basically be honored. What property will pass through the estate and what will pass by its own terms?
Any property that you hold in your name alone. So let's say you own real property in the name of Ken Landau and nobody else is on that deed. Your executor will be authorized to dispose of that property in accordance with the terms of your will. Also, bank accounts, many times they only have one person's name on it. So that kind of thing, brokerage accounts, any kind of personal property, the executor is obligated to collect value and then distribute, again, in accordance with the terms of your will.
Now, a bank account, we discussed earlier, it's probably better if there's a beneficiary on it.
Always better if you name a beneficiary on an asset that you want to pass to a specific person at your death, because all they have to do is get a certified death certificate and bring it to the asset holder, and that's how they collect it.
And also, it could be good to have joint property, maybe a checking account, maybe some account with someone you trust, so is cash immediately available to pay expenses?
What you're describing is a convenience account, okay. And that's an account that typically the person who owns that account doesn't want the joint holder to receive all the money themselves, but instead use the money to pay for their bills or funeral expenses or have cash on hand at the time of their death.
Or perhaps both, but just this way to have cash on hand without any further action.
Right.
Okay. And as you said, it's 401ks and other accounts or brokerage accounts may be frequently overlooked.
It's very, very important to make sure that any kind of retirement account is not overlooked. And this is something that we go over at the will consultation, because there could be income tax implications to not having a designated beneficiary, and that is something that the executor would collect on behalf of the estate, but may have to pay income taxes depending on the asset.
Okay, are there other questions that you might ask someone at the will checkup?
I always ask, who do you want to be in charge of collecting your assets, paying your liabilities, and then making distribution in accordance with the terms of your will? And that person has to be somebody that you can trust to carry out that job. And it is a job. There's a lot of work to do. The law does provide that the executor gets paid for that job in terms of commission, which is based on a sliding scale based on the value of your estate. We also discuss whether or not, if you have young children or even children that you want to create a trust for, if you want to decide at what point and for what reasons your children will receive their money. I'll discuss a testamentary trust and who the trustee is going to be.
And also important, if the children are minors, you can name people you would like to be guardians of the children. Forget about their property, but guardians of themselves, of the children.
That is the person that will be raising your children. And yes, that is what I discuss with, let's say, a young couple that comes in with young kids. The guardian would be the person who takes over raising your children, and that person would go to the trustee to get money to help care for your kids' financial needs.
Okay. And what circumstances may there be when people need to have that checkup?
I would say if any life event occurs, if your spouse passes away or somebody is estranged from you that was named in a prior will, or somebody that is named as an executor under your will and that person passed away, or you just want to change it. And if you start a family and you have young kids, it's very important to have a guardian appointed in the awful, God forbid, you and your spouse pass away and no one's there to raise your children.
And this is especially for children under 18.
It is absolutely for children under 18. It could be for children over 18 if you...
For the property.
For the property.
Okay. And as the needs of children or grandchildren change, you may want to adjust your wishes, the beneficiaries under your will.
Right. So if you have a some kind of benefit for one of your grandchildren under the will, let's say an education trust, and now your grandchild has graduated college, is getting married, and you want to change the will, that's another very good reason and common when people come in to have a will consultation. Another common example is when someone's spouse passes away and the surviving spouse is now considering what's going to happen to the assets that they inherit.
And I guess also if there's a divorce.
Yes, that is also another very common reason.
Or remarriage. Things, as life cycle events, your remarriage, children's remarriage, you may change the way where you want your estate to go. Second
marriage, yes. But when you come in to update your will and it's because you're getting married for a second time, other documents come into place, such as maybe a prenuptial agreement.
Okay. What about other documents that a person should have in addition to a proper, up-to-date, validly executed will?
So after I'm done with the will consultation, I always recommend what's called a power of attorney and a healthcare proxy. Those two documents together are very important because in the event you yourself become disabled, with those two documents together, your family can avoid having to have a guardian appointed over you so that they can access your finances, pay your bills.
Or may help with healthcare decisions.
And make healthcare decisions, or even just convey your own healthcare decisions to the medical staff.
In terms of timing, the will doesn't go into effect until you pass on.
Correct.
And the healthcare proxy and the living will only control things while you're alive.
That's right. Both the power of attorney and the healthcare proxy die with you effectively.
Right, and there are different ways of making provisions so they still are valid if you become disabled.
There is a power of attorney. There's a certain type of power of attorney called a durable power of attorney, which will remain in effect in the event you become incapacitated.
And the various nuances, you can help people understand them and do this as part of the package when you prepare or update their will.
I would say yes, and power of attorney is actually a very complicated document, and you really need to sit down with a lawyer to go over
And
that.
sometimes there may be special forms required for certain institutions.
Yes, okay. That is true.
And again, a will can be changed for a variety of reasons at any time or many times, assuming a person's competent to do so, but it should be changed properly.
Exactly.
Otherwise, it may invalidate the whole will, or your provision may not be honored, so it's important to consult the lawyer about doing that.
Absolutely.
Now, what about the handling of the will? What should or should not be done with that?
So, when somebody comes into my office to sign the will, after the will is fully executed, meaning being signed in the presence of two witnesses, I also recommend to my client, or I will advise them, if they take the original will, they must keep it in a safe place, because if they lose it, it's presumed that they revoked it. If they leave the original document with me and I lose it, that presumption of revocation does not arise.
Right, so they would have a copy even if they leave the original with you for safekeeping.
Yes.
And it's important that if they want to change it, they not rip it up or innocently alter it in any way in an attempt to copy it. because the court doesn't know if they did it, and the court may not know what the intention was.
That is correct. You would need to either do a codicil or a whole new will, and I don't recommend codicils because then there are 2 documents that you have to probate to have a valid will.
And also, it's important it should not be tampered with. If someone takes out the staple to photocopy it, a court may not know if it was tampered with.
Well, if it was tampered with by someone taking staples out, even just to make a copy of the will, the court will require an affidavit explaining why those staples were taken out.
So it's best to avoid doing that.
It's absolutely best to avoid doing that.
Okay, we just have a moment left in the program. Any other final advice you would like to give about the will checkup or do's and don'ts?
I would just say that it's really important for you to consider your own needs with regard to a will, power of attorney, and a healthcare proxy, because they're very specific to you, to your assets, to what you want to do with them at your death or during life. And those 3 documents together, actually the power of attorney and healthcare proxy, give you a lot of flexibility to do that.
And they also ensure that your plan and your wishes will be honored. And
yes,
that's what you're looking for, is peace of mind and some certainty. And you're actually, it's also a much more, it's a much cheaper legal service than litigation or uncertainty or extensive legal proceedings,
which you would want to spare your family from suffering,
and yourself, and depleting your estate.
Exactly.
Okay, so for all those reasons, it's good to have the will and check it from time to time,
and to keep it in a safe place. Yes.
Okay, and so I just want to mention that whatever you've heard is valuable information, but it's not intended to be legal advice. You should consult your own attorney for advice about your personal situation. And it's good to, as you've heard, you've gotten a lot of good information from our guest, Patricia A. Harold, and just be very careful of any wills over the internet or in books, because if they miss something, if one provision doesn't apply to your situation, to New York State, it's just going to be a can of worms and very expensive to resolve. If you've missed any part of the program, you can search WHPC on iTunes for a free podcast, and please join us next week at this same time on Law You Should Know here on WHPC 90.3, the voice of Nassau Community College, and also over the internet at nccradio.org.